Senator Leahy.
Thank you, Chair Durbin. Judge, congratulations again on your nomination to our nation's highest court. You're an impressive jurist. I hope the broader public sees that, and I've enjoyed the opportunity to meet your family here yesterday. And but I thought before I begin my questions, I was going to respond to something the junior senator from Texas said yesterday. He suggested the Democrats exacted a political agenda by opposing the nomination of then Judge Gorsuch to the Supreme Court. I kind of chuckle at that because, along with others, I and others repeatedly and clearly stated substantive concerns with Justice Gorsuch's nomination. I explained my votes on the record. There's no political agenda. I contrast that with Republicans' treatment of then Judge Merrick Garland. We're still waiting today for Republicans to explain on the record what kind of substantive concerns they had with Merrick Garland, that they blocked him for over a year and would not even allow a vote on his nomination. Apparently, because of a politically driven agenda. All I'm saying is let's make history this week, but let's not rewrite it. This is a historical time. Judge Jackson, one of the topics we discussed in our meeting was our respective experiences. You as a former federal public defender, myself as a prosecutor. As a federal public defender here in Washington, you were assigned to and then represented clients who couldn't otherwise afford a lawyer. One of the valuable lessons I learned as a prosecutor was this: for our criminal justice system to function properly, you have to have skilled, dedicated lawyers on both sides of the issue, both the prosecutor and the defense attorney. It's equally essential for judges to have a nuanced and a balanced understanding of our criminal justice system if we're going to have justice done. Now, it's really concerning, it's confusing that some view your background as a federal public defender as some kind of a liability. Those of us who have spent time in courtrooms know you have to have both the skilled prosecutor and a skilled defender. I believe it, in fact, I don't think of it as a liability. I think it's going to be a major asset to you. And I think it should be welcome on the Supreme Court. In fact, if you're confirmed to the court, as I look back over, you're going to be the first former federal public defender on the court. You're going to be the first nominee since Justice Thurgood Marshall with a significant background in criminal defense. That's pretty impressive. So, all of us should want that represented in the Supreme Court, because decisions on the Supreme Court can have a lasting impact on our criminal justice system. My question is this: I believe that your experience as a federal public defender has made you a better judge, helped you maintain impartial and balanced perspective in criminal and other cases, and I assume you would agree with that.
Yes, Senator. I think that experience in the criminal justice system, whether, as you say, on the prosecution side or the defense side, having actual experience is an asset as a judge. You understand the way the system works, and as a defense counsel, you have interacted with defendants in a way that, as a judge, at least as a trial judge, I thought was very beneficial. One of those ways is it helped me to develop a sense of the need to communicate directly with defendants. And, it didn't change, I think, in any way the outcomes of the cases when I was a trial judge, but I understood from my time as an appellate defender that a lot of defendants go through the system and don't really understand it. And the problem with that from our society's standpoint is that when people go through the criminal justice system and don't have a good understanding, they tend to not take responsibility for their own actions. They tend to be bitter and feel as though the justice system has wronged them. And so while they're doing their time, rather than reflecting on the fact that this is the consequence that they have to face for actually committing a crime, instead of doing the work to rehabilitate themselves, they're focusing on how wronged they are, how victimized they feel. And so what I decided as a trial judge was that I was going to make sure that everyone who was in my courtroom, and especially the defendant, understood all of the procedures that we were going through, all of the steps. I spoke directly to them. I asked them, do you understand what's happening? Because I wanted them to know. And then even perhaps more importantly, as I said about my child pornography cases, I focused on the harms of the behavior that was at issue. When I sentenced a defendant, I made clear in every case, here is the problem. This is what you've done. Here is the damage to our society. And I don't know that I would have done that if I had not been a criminal defense lawyer.
Well, and that's sort of what, I was getting to, the fact that you have that experience. It's obvious you don't get, as a public defender, you don't get to choose your clients. It's not like you're going out there picking and choosing. You're told you're going to defend this person, but they're given that right under the Sixth Amendment. And you're a member of the bar or judge or public defender, you take an oath to uphold the Constitution. And the Sixth Amendment's a pretty important part of it, wouldn't you say?
Absolutely, Senator.
And it's also a pretty important part for indigent defendants. Is that not correct?
That is correct, especially for indigent defendants, because they are determined to not be able to afford counsel. And as you said, Senator, for a judge, it is crucial that you have arguments that are being made and presented on both sides of the issue. That is what allows for judges to reach just results in cases, and it's what makes our system so exemplary.
It also guarantees that our Constitution is going to be followed. I think it's important you went around with Senator Doug Jones, who's highly respected in the Senate on both sides of the aisle, but you got to meet other senators. I was delighted you came to spend time in my office, and you noted in your public remarks at the White House when you were nominated that your parents were married for 54 years, and both public servants in their own right. And they were proudly watching you being announced by the president, and I must admit, watching them the last couple of days, they're proudly watching you here, as have other members of your family. Your younger brother became a police officer, detective in Baltimore before serving the Army, two tours of duty in the Middle East, two uncles that served as police officers. So I'm not really surprised that you understand law enforcement. The National Fraternal Order of Police has expressed strong support for your nomination. In fact, in their letter dated February 25th, 2022, they said you have considered the facts and applied the law consistently and fairly on a range of issues. And they went on to say there's little doubt you have the temperament, intellect, legal experience, and family background to earn this appointment. And they added, We are reassured that should she be confirmed, she'd approach her future cases with an open mind, treat issues related to law enforcement fairly and justly. Chair Durbin, I'd ask consent that the letter from the Fraternal Order of Police be included in the record at this point.
Without objection.
Now, that's a statement from the largest law enforcement labor organization in the United States. What do you say to people who say you're soft on crime or even anti-law enforcement because you accepted your duties as a public defender?
Thank you, Senator. I would make I'd make three observations in response to those critiques. The first is that as someone who has had family members on patrol and in the line of fire, I care deeply about public safety. I know what it's like to have loved ones who go off to protect and to serve, and the fear of not knowing whether or not they're going to come home again because of crime in the community. As you said, my brother patrolled the streets of Baltimore, and I had two uncles who were career law enforcement, including one who became the chief of police of the City of Miami Police Department in the 1990s. So crime and the effects on the community and the need for law enforcement, those are not abstract concepts or political slogans to me. The second observation that I would make is that as a lawyer and as a citizen, I care deeply about our Constitution and about the rights that make us free. As you say, criminal defense lawyers perform a service, and our system is exemplary throughout the world precisely because we ensure that people who are accused of crimes are treated fairly. It's very important to me in that capacity as a lawyer and as a citizen. I'm sorry. I was just going to say the third thing I would say is as a judge. As a judge, I care deeply about the rule of law. And I know that in order for us to have a functioning society, we have to have people being held accountable for committing crimes. But we have to do so fairly under our Constitution. As a judge who has to decide how to handle these cases, I know it's important to have arguments from both sides, to have competent counsel. And it doesn't mean that lawyers condone the behavior of their clients. They're making arguments on behalf of their clients in defense of the Constitution and in service of the court. And it is a service.
Now, I know in our conversation, I'd mentioned my own experience as a prosecutor. I wanted the best defense attorney on the other side because you want to make sure that as the trial went on, everything was done properly. And let's talk about Guantanamo Bay. It's been controversial, and we've had two presidents, one Republican, one Democratic, who said they wish it could be closed. But the fact is, individuals were detained there. The whole world was watching this. I know I heard from people I respect throughout the world asking questions about Guantanamo. And that's precisely the situation. We want our best and our brightest lawyers to step into the fray, however politically controversial. We have to make sure that we do not become unmoored from our core commitments to the rule of law, but that also, both in our own country and outside our country, people can see that we're following that. So you were in private practice, when you took on these cases, uncharted legal waters, more, what principles drove you to get involved with cases in such a difficult time in Guantanamo Bay?
Well, thank you, Senator. And I do want to clarify, when I first started working on these cases, I was an assistant federal public defender. The Supreme Court in 2004 issued 2 opinions that began this group of cases and these issues. And this was in the wake of the tragic and terrible attack on this country in 9/11, and the executive's use of authority to detain enemy combatants at Guantanamo Bay. In 2004, the Supreme Court ruled that the executive did have the authority to make those detentions in one case, and then in another case, the Supreme Court ruled that anyone so detained could file a legal challenge. They had habeas rights, and as you know, habeas is in the Constitution. In 2005, I joined the Federal Public Defender's Office, and those cases started coming in. The requests from detainees asking for legal representation consistent with our constitutional scheme to have help to file their habeas petitions. This was very early in the days of these kinds of legal actions. There was a lot unknown about what these petitions could look like, what the arguments could be made and considered by the court, and perhaps most importantly, what the facts were related to any of these individuals, because almost everything was classified. So defense counsel was getting these people in with no information. I was in the appellate division of my office, and as an appellate defender, I worked on legal issues. I was paired with I was assigned by the federal public defender. I was an assistant federal public defender, and I was paired with a trial defender who attempted to do the fact gathering, who traveled to Guantanamo Bay. I never traveled there or anything like that. I worked on the law. And as you noted, the law was very uncertain. This was brand new. And people were trying to figure out what are the limits of executive authority in this context. We knew that the Constitution was not suspended, even though we had this emergency. So what did that mean with respect to these individuals? I filed as a federal public defender. I was assigned to work on 4 cases. And I filed almost identical petitions, because what you're doing, especially when you have no facts, is just preserving legal arguments for your clients. That is consistent with what lawyers do. And then you mentioned private practice. So I went into private practice in, I believe it was 2007. And by that time, lots of private practices around the country had started taking on these cases, because there were lots of people who needed representation. And so pro bono practices were receiving requests, usually through nonprofits. And one of the individuals that I had represented as a defender ended up being assigned to my firm, unbeknownst to me. So I arrive at my firm, and the partners realized that this same person was someone that, according to the docket, I had previously represented, and they asked if I would review some of his materials and continue the representation. That was the only person that I represented in the context of my private firm who was a detainee. I worked on a couple of habeas briefs for judges and for a variety of nonprofits, including the Rutherford Institute, the Cato Institute, and the Constitution Project, who were all interested in making arguments to the Supreme Court that was considering these very novel legal issues.
You know, I sit here and I think of the 20 Supreme Court nominees I've gotten to vote on over my years here, and I think of the remarkable praise you got from the former Republican House Speaker Paul Ryan, whom most of us know well. He did mention his politics may be different than yours, but his praise for your intellect, for your character, for your integrity is unequivocal. That's powerful praise. And I think it goes to a really fundamental point, and that's this. One doesn't have to have the same political beliefs or ideologies as a judicial nominee to recognize their integrity and intellect. When I voted to confirm Chief Justice John Roberts of the Supreme Court, I cast that vote knowing very well that he and I would disagree on many policy and political issues. But I voted yes because I believed that he had what it takes to serve as an impartial, fair Chief Justice who would uphold the rule of law, and I want to take it out of partisan politics. Now, what would you say to people whose politics may be different than yours, like Speaker Ryan, who has endorsed you? What would you say to those people about your readiness to serve as an even-handed, unbiased Supreme Court justice?
Thank you, Senator. I would say that I am committed to serving as an even-handed Supreme Court justice if I'm confirmed by this body. And I have a record over the past decade that's precisely how I've treated all of my cases. And I've been serving in the District of Columbia, both as a trial judge and as an appellate judge, and we see some of the most politically contentious issues. My record demonstrates my impartiality.
Well, I'd go along with that because, and I watched this court. I used to go there as a young law student, sit in the back and just watch it. I continue to watch it. I see the chief judge of the federal district court, Judge Beryl Howell, who I was privileged to have her serve as my chief counsel on this committee, and learned from her then. I learned from her now. But I also, as a lawyer, I hear a lot of talk about reversal rates. Now, no judge goes without being reversed somewhere. If they're never reversed, they haven't heard many cases. But your time in the D.C. District Court, less than 2% of your more than 550 cases were reversed. Considering the fact that the D.C. Circuit reverses an average of 13% of the cases, it hears. You got a pretty good record, but what does a judge who's been reversed? What do they take from that reversal? What do they or what should they think about it?
Well, you obviously look at it very carefully. What it means is that a panel of judges who've reviewed what you determined for some reason has decided differently. And there are times when panels of judges decide differently because they are making a new statement about the law, or they're establishing a standard that had not previously been the case in the area. And so you learn, oh, this is a new standard now that I need to apply. There are times when you disagree, that people can disagree about the way in which the law works. And that's why we have panels, because judges can have different perspectives and in good faith reach different results. And so obviously when you're on the trial court, the Court of Appeals is binding, and they tell you, in this case, no, the result is something different. And so you learn.
Anytime I had an opportunity to argue a case at an appellate level, I don't think I ever thought about who nominated or appointed the judges as before. I just want to know what I would think about their experience. And I would think about that when I made the argument. Now, I don't think I've ever had the opportunity to argue before anybody had your breadth of legal experience here. You served as a federal trial court, a federal appellate court judge for almost 10 years. You clerked at all three levels of the federal judiciary. You practiced law as a federal public defender in private practice, and I know we confirmed you as a member of the U.S. Sentencing Commission. This may seem like an easy question, but I just ask you that you've had such broad experience, but they're all different in a way. How does that shape your approach when deciding a case?
Well, thank you, Senator. As I mentioned at the beginning, I have a methodology that I apply when I'm deciding cases, and maybe my various experiences helped me to get to the point of understanding the importance of impartiality, staying in my lane as a judge, because the prior experiences were different roles in the system. Because I saw the different roles, I think I have a good appreciation of what it means to be a judge and the limitations on my own authority. The Sentencing Commission was a policymaking branch of the judicial branch that the commission and the commissioners developed sentencing policy. Congress delegated that authority to create the commission, and so they're doing the policy work, gathering data, making recommendations. That is totally different than the work that I do as a judge. Advocacy, on behalf of your clients, making critical arguments, the best arguments you can come up with, is a service to the court, but it's a totally different thing than operating as a judge. And so I think that having had those various experiences, I'm now really mindful of my role and limitations in the judicial branch.
Well, and the president referred to you as a proven consensus builder, and I think he was also thinking of your predecessor, Justice Breyer, in that regard. And I think over the years how important that is, even in a body like the U.S. Senate. I see Senator Tillis here. He and I have worked together on IP issues. Senator Cornyn and I on freedom of information issues. Senator Grassley and I on other issues. Senator Graham and I on various issues. And usually, in the Senate at least, if you work across the ideological spectrum, you get better results. So let me ask you, how would you describe your approach to building consensus on cases related to issues like intellectual property that are less likely to break along traditional ideological lines?
Thank you. Thank you, Senator. One of the things that I was able to do when I worked on the Sentencing Commission was work with people who had very different perspectives than I did about the criminal justice system and come to consensus. It's very important, as you've said, to try to find common ground. And Justice Breyer was such a wonderful model, a role model for that kind of ability as a Supreme Court justice. It's something I learned from him and something I tried to model in my work on the commission, that I try to model in my work as an appellate judge, and that I would model or do if I were confirmed to the Supreme Court.
Thank you, Chair Durbin.
Thank you, Senator.